Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in City and County of San Francisco v. EPA. In this case, the court considered this issue. Does the Clean Water Act allow the Environmental Protection Agency, or an authorized state, to impose generic prohibitions in national pollutant discharge elimination system permits that subject permit holders to enforcement for violating water quality standards, without identifying specific limits to which their discharges must conform? The case was decided on March 4, 2025. The Supreme Court held that the Clean Water Act does not authorize the EPA to include end-result provisions in wastewater discharge permits. Justice Samuel Alito authored the 5-4 majority opinion of the court. First, while rejecting San Francisco's broader argument that all limitations must be effluent limitations, the court focused on Section 1311b, 1 CS authorization of any more stringent limitation necessary to meet water quality standards. The terms limitation, implement, and meet in this provision require the EPA to specify concrete actions permittees must follow, not merely mandate end results without guidance. A proper limitation is a restriction imposed from without, not a directive that forces permittees to determine compliance measures themselves. Second, Congress deliberately abandoned the pre-1972 backward-looking approach that had directly penalized polluters for water quality violations. The CWA's permit shield provision, which protects compliant permittees from penalties, would be undermined if end-result requirements could expose permittees to massive penalties despite following all specified steps. Additionally, the EPA's interpretation offered no solution for fairly allocating responsibility among multiple dischargers affecting the same body of water. Determining necessary compliance steps is the EPA's responsibility, and Congress has provided the agency with sufficient tools to make these determinations without resorting to end-result requirements. Justice Amy Coney Barrett authored a dissenting opinion, in which Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson joined. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Alito delivered the opinion of the court. Under the Clean Water Act, CWA, the Environmental Protection Agency, EPA, and authorized state agencies may issue permits that impose requirements on entities that wish to discharge pollutants, a broadly defined term, into the waters of the United States. Permits issued by these agencies include what the CWA calls effluent limitations, that is, provisions that specify the quantities of enumerated pollutants that may be discharged. It is also common for permits to set out other steps that a discharger must take. These may include testing, record-keeping, and reporting requirements, as well as requirements obligating a permittee to follow specified practices designed to reduce pollution. None of these so-called narrative requirements is at issue here. Instead, this case involves provisions that do not spell out what a permittee must do or refrain from doing. Rather, they make a permittee responsible for the quality of the water in the body of water into which the permittee discharges pollutants. When a permit contains such requirements, a permittee that punctiliously follows every specific requirement in its permit may nevertheless face crushing penalties if the quality of the water in its receiving waters falls below the applicable standards. For convenience, we will call such provisions end-result requirements. The permittee in this case is a wastewater treatment facility owned by San Francisco. For the past 5 years, the facility's permit has included 2 end-result requirements, and if those provisions are upheld, the city could be heavily penalized even though it was never put on notice that it was obligated to take any specific step other than those it undertook. San Francisco argues that the end-result provisions in its permit are not authorized by the CWA, and its position is supported by many other similarly situated cities, including New York, the District of Columbia, Boston, and Buffalo, as well as national and state associations whose members collectively provide wastewater and stormwater services to the majority of the people in this country whose homes are connected to sewers. We hold that the 2 challenged provisions exceed the EPA's authority. The text and structure of the CWA, as well as the history of federal water pollution legislation, make this clear. And resorting to such requirements is not necessary to protect water quality. The EPA may itself determine what a facility should do to protect water quality, and the agency has ample tools to obtain whatever information it needs to make that determination. If the EPA does its work, our holding should have no adverse effect on water quality. To understand the issue before us, it is helpful to take a brief look back at the history of federal water pollution legislation. For most of the nation's history, the federal government played a secondary role in this field. In 1948, however, Congress passed the Federal Water Pollution Control Act, WPCA, which represented a cautious expansion of federal authority. The WPCA reaffirmed the long-accepted principle that controlling water pollution was primarily a state responsibility, but it also declared that the pollution of certain interstate waters had become a public nuisance, and was subject to abatement in a suit brought by the Attorney General on behalf of the United States. Over the next 24 years, the WPCA was amended numerous times, and the federal role gradually grew, but the basic structure of federal enforcement actions remained the same. The starting point was the identification of a body of water with substandard water quality. After that, federal authorities had to work backward and prove that a particular entity should be held responsible for the problem. Both the original version of the 1948 Act and all amendments enacted before 1972 proved to be ineffective due in part to this backward-looking model. By 1972, the WPCA's inadequacy was apparent, and Congress made a fresh start. It amended the WPCA by deleting all its provisions and substituting what is now generally known as the Clean Water Act. The CWA jettisoned the WPCA's retrospective approach and aimed directly at the sources of pollution. A critical component of the CWA scheme is the National Pollutant Discharge Elimination System (NPS), which makes it unlawful to discharge pollutants into covered bodies of water unless authorized by permit. Permits issued under this program may contain several different types of provisions. Some are known as effluent limitations, which are defined as restrictions on the quantities, rates, and concentrations of chemical, physical, biological, and other constituents. Section 1311b, 1, subparagraphs A and B, require compliance with one type of effluent limitations, those that are based on what can be achieved using specified pollution treatment technologies. In most cases, these technology-based limitations are sufficient, but when they are not, NPAD's permits also include water quality-based effluent limitations, WQBELs. These WQBELs, unlike technology-based effluent limitations, are set without regard to cost or technology availability. Instead, they permit only those discharges that may be made without unduly impairing water quality. In addition to these effluent limitations, it is common for permits to include requirements that do not set numerical limitations on allowed discharges. One example, which is apparently common in so-called general permits, is a provision demanding that permittees follow certain best practices that aim to limit pollution. Under the NPS system, permittees have a very strong incentive to comply with all permit terms. For one thing, the CWA gives the EPA a very big stick. Permittees that do not comply may be hit with enormous civil penalties and may face criminal prosecution for knowing or even negligent violations. At the same time, the CWA holds out an enticing carrot. Under what is known as the Permit Shield provision, an entity that adheres to the terms of its permit is deemed to be compliant with the Act. The case now before us involves a particular type of public wastewater treatment, one that processes both wastewater, water that has been used in a home, and stormwater, rainwater that does not sink into the ground. Many major cities have such systems, and they present special problems. During periods of heavy precipitation, the combination of wastewater and stormwater may exceed the facility's treatment capacity, and the result may be the discharge of untreated water, including raw sewage. This problematic feature of combined facilities was recognized long ago. Installing a new system that handles stormwater and wastewater separately is enormously expensive. To address the problem of CSOs, the EPA adopted its CSO control policy, which requires municipalities with combined systems to take prescribed measures and to develop and implement a long-term control plan. The CSO policy provides for a two-phase permitting process. During Phase I, permits require municipalities to implement 9 minimum controls and to develop a long-term plan. Then, during Phase II, that plan must be implemented. In 2000, Congress amended the CWA and gave the CSO control policy the force of a statute. The City of San Francisco operates 2 combined treatment facilities: the Bayside Facility, which discharges into San Francisco Bay, and the Oceanside Facility, which empties into the Pacific Ocean. The permitted issue in this dispute concerns only the Oceanside Facility, which treats water from 250 miles of sewers and serves approximately 250,000 residents. For many years, the Oceanside Facility's NPA's permit was renewed without controversy, but in 2019, the 2 end result requirements that San Francisco now challenges were added. The first of these prohibits the facility from making any discharge that contributes to a violation of any applicable water quality standard for receiving waters. The second provides that the city cannot perform any treatment or make any discharge that creates pollution, contamination, or nuisance as defined by California Water Code Section 13050. The California Regional Water Quality Control Board for the San Francisco Bay region approved the final Oceanside NPA's permit, and the EPA did the same. San Francisco appealed to the EPA's Environmental Appeals Board (EAB), objecting to, among other things, the 2 new provisions just noted. The EAB rejected San Francisco's challenge, and the city then filed a petition for review in the Ninth Circuit. A divided Ninth Circuit panel denied that petition. In dissent, Judge Collins argued that the CWA draws an explicit distinction between agency-imposed limitations and water quality standards themselves. We granted certiorari to decide whether the EPA can impose requirements like those at issue. Contending that the Ninth Circuit misreads Section 1311b, 1c, San Francisco leads with the argument that all limitations imposed under Section 1311 must qualify as effluent limitations. The statutory text dooms this broad argument. Where Congress includes particular language in one section of a statute but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. We have invoked this canon time and time again, and it is fatal to San Francisco's argument here. Sections 1311b, 1a, and b refer to effluent limitations, but the very next provision, Section 1311b, 1c, refers instead to any more stringent limitation. We cannot believe that Congress omitted the term effluent from Section 1311b, 1c, simply because it wanted to save ink or assumed that regulators and interested parties would understand that the omission of the term was inconsequential. Other provisions of the CWA support this conclusion by describing Section 1311 as authorizing the EPA to impose effluent or other limitations. These reasons convince us that San Francisco's argument is wrong, but if more were needed, it is telling that the city's interpretation would lead to either drastic consequences that the city is unwilling to embrace, or a very loose interpretation of the term effluent limitation that would undermine the city's argument. As noted earlier, it is common for permits to contain narrative provisions requiring permittees to do such things as following certain best practices. These provisions do not directly restrict the quantities, rates, or concentration of pollutants that a permittee may discharge, and therefore they do not fit easily within the definition of an effluent limitation. Nevertheless, the city acknowledges their legitimacy, and if that is correct, it must follow either that 1. Section 1311b, 1c, authorizes the imposition of limitations other than effluent limitations, which would, of course, defeat the city's argument, or 2. The statutory definition of an effluent limitation should be read very loosely, which raises the question why this broad interpretation would not encompass the provisions at issue here. Under either alternative, the city is on perilous ground. These problems overwhelm any help that the city can derive from the fact that Section 1311 is titled Effluent Limitations. The title of a statutory provision can inform its interpretation, but it is not conclusive. And here, the title of Section 1311 is not enough to win the day for the city. Section 1311 is a lengthy provision, and most of its subsections concern effluent limitations. The title Effluent Limitations provides a rough description of the provision's general sweep, but it cannot be read as doing more than that. In addition to the broad argument discussed above, San Francisco advances a narrower alternative, namely, that even if Section 1311b1c is not limited to effluent limitations, it does not authorize EPA to impose NPAT permit requirements that condition permit holders' compliance on whether receiving waters meet applicable water quality standards. We agree with this argument. As the city maintains, the text, structure, and pre- and post-enactment context support this interpretation. We begin with the text of Section 1311b, 1c, which, as noted, requires a permit to contain, in addition to effluent limitations, any more stringent limitation that is necessary to meet certain water quality standards that are imposed under state law or any other federal law or regulation, and any more stringent limitation that is required to implement any applicable water quality standard established pursuant to this chapter. All the italicized terms in the preceding sentence suggest that the most natural reading of Section 1311b, 1c, is that it authorizes the EPA to set rules that a permittee must follow in order to achieve a desired result, namely, a certain degree of water quality. We start with the term limitation. As used in the relevant context, a limitation is a restriction or restraint imposed from without, as by law. A provision that tells a permittee that it must do certain specific things plainly qualifies as a limitation. Such a provision imposes a restriction from without. But when a provision simply tells a permittee that a particular end result must be achieved, and that it is up to the permittee to figure out what it should do, the direct source of restriction or restraint is the plan that the permittee imposes on itself for the purpose of avoiding future liability. In other words, the direct source of the restriction comes from within, not from without. We do not dispute that the term limitation is sometimes used in a looser sense, but our task is to ascertain what the term means in the specific context in question. And here, our interpretation of the meaning of the term limitation in Section 1311b, 1c, must take into account the way in which the term is used in the two preceding statutory subsections, Sections 1311b, 1a, and b. In both those provisions, the limitations are imposed directly by the EPA, and it is therefore natural to presume that the term has a similar meaning in Section 1311b 1c. So the use of the term limitation in Sections 1311b, 1a, and b provides an opening clue that the EPA's interpretation of Section 1311b, 1c may be wrong. The terms implement and meet point in the same direction. The implementation of an objective generally refers to the taking of actions that are designed to give practical effect to and ensure of actual fulfillment by concrete measures. Section 1311b, 1c, tells the EPA to impose requirements to implement water quality standards, that is, to ensure by concrete measures that they are actually fulfilled. Simply telling a permittee to ensure that the end result is reached is not a concrete plan for achieving the desired result. Such a directive simply states the desired result. It does not implement that result. Section 1311b, 1c's other directive, that the EPA impose limitations that are necessary to meet certain water quality standards is similar. The verb to meet, in the sense operative here, means to comply with, fulfill, satisfy, or to come into conformity with. Thus, a limitation that is necessary to meet an objective is most naturally understood to mean a provision that sets out actions that must be taken to achieve the objective. In assessing what the directives in Section 1311b, 1c, mean, it is helpful to consider the use of the relevant terms in everyday speech. Suppose a state requires that all schools meet certain standards of math proficiency, and suppose the principal of a school calls a faculty meeting and instructs the teachers to implement those standards. The principal's obvious expectation would be that the teachers would devise and implement a plan to make sure that the desired end is met. It is unlikely that the principal would be happy if the teachers simply told their students that a state math proficiency test would be administered and that they should make sure they passed. That would not constitute the implementation of the desired end, i.e., meeting the state's standard of math proficiency. Attempting to counter this interpretation, the EPA stresses Section 1311b, 1c's use of the term any in the phrase any more stringent limitation, arguing that any is a very broad term. That argument misconstrues the term's effect. The adjective any is indeed a broad term, but it cannot expand the reach of the noun it modifies. A reference to any mammal would capture all mammals, but it would not encompass a bird or fish. Similarly, Section 1311b, 1c, encompasses any limitation that is necessary to meet or implement water quality standards, but not provisions that do not fall within that category. The text of the CWA militates against the government's interpretation of Section 1311b, 1c, for yet another reason that stands out when the history of federal water pollution control legislation is kept in mind. Under the government's reading, a permittee may be held liable if the quality of the water into which it discharges pollutants fails to meet water quality standards. Before 1972, the WPCA contained a provision that did exactly that in no uncertain terms. But when Congress overhauled the WPCA in 1972, it scrapped that provision and did not include in the new version of the Act anything remotely similar. Under these circumstances, the absence of a comparable provision in the CWA is telling. This glaring void resulted from a deliberate and prominent policy choice. As recounted earlier, before 1972, the basic structure of federal enforcement efforts was a lawsuit seeking to hold a polluter accountable for contributing to what amounted to or was expressly termed a violation of water quality standards. Building on the enforcement model originally adopted in the 1948 Act, the 1965 amendments of the WPCA required the adoption of water quality standards, and they then provided that violators of these standards were subject to suit by the United States. That is where matters stood until 1972, when Congress again amended the WPCA by deleting its entire text and substituting what is now popularly called the CWA. This overhaul of the WPCA continued to require the adoption of water standards, 33 U.S.C. Section 1313, but the revised statutory text conspicuously omitted any provision authorizing either the United States or any other party to bring suit against an entity whose discharges were contributing to a violation of those standards. This omission cannot be viewed as accidental or inconsequential. The repealed enforcement provision went to the heart of what Congress viewed as a major defect in the old scheme. As we have noted, the 1972 overhaul aimed to facilitate enforcement by making it unnecessary to work backward from an overpolluted body of water to determine which point sources were responsible and thus subject to suit. Instead, the amended WPCA sought to achieve acceptable quality standards by means of direct restrictions on polluters. The government's interpretation would undo what Congress plainly sought to achieve when it scrapped the WPCA's backward-looking approach. It is a fundamental canon of statutory construction that the words of a statute must be read in their context and with a view to their place in the overall statutory scheme. Thus, in construing Section 1311, we must also take into account the broader statutory scheme, and at least two features of that scheme point in favor of our interpretation. The first is the so-called permit shield provision, 33 U.S.C. Section 1342K, under which a permittee is deemed to be in compliance with the CWA if it follows all the terms in its permit. This protection is very valuable because violations of the CWA, even if entirely inadvertent, are subject to hefty penalties. The CWA imposes a regime of strict civil liability, and a party that violates a permit term may be fined up to $25,000 per day per violation. Section 1319D. As San Francisco explains, it may take months to gather the information necessary to detect a drop below the applicable water quality standards, and after substandard water quality is detected, it may take some time to devise and implement appropriate corrective measures. Indeed, there may be occasions, such as the multiple discharger situation we discussed below, when there is nothing a permittee can do to bring about a prompt correction. For these reasons, the potential civil penalties for noncompliance can mount up and reach enormous sums. In a pending suit against San Francisco regarding the Bayside facility, the penalties sought are $10 billion. In addition to all this, a permittee who is found to have acted knowingly or even negligently may be criminally prosecuted. Section 1319C. Because of the harsh penalties for violating the terms of a permit, the permit shield is invaluable. Because of it, a discharger that complies with all permit conditions can rest assured that it will not be penalized. But the benefit of this provision would be eviscerated if the EPA could impose a permit provision making the permittee responsible for any drop in water quality below the accepted standard. A permittee could do everything required by all the other permit terms. It could devise a careful plan for protecting water quality, and it could diligently implement that plan. But if, in the end, the quality of the water in its receiving waters dropped below the applicable water quality levels, it would face dire potential consequences. It is therefore exceedingly hard to reconcile the government's interpretation of Section 1311B, 1C, with the permit shield. And contrary to the government's contention, the possibility that a court might ultimately exercise its broad discretion to mitigate penalties is not enough to make up for disarming the shield. One final structural feature cements the case against the EPA's interpretation: the absence of any provision dealing with the problem that arises when more than one permittee discharges into a body of water with substandard water quality. As previously explained, it is hard to believe that the 1972 Congress used Section 1311B, 1C, to perpetuate, in camouflaged form, the backward-looking enforcement scheme in the prior version of the WPCA, and it is even harder to accept the proposition that Congress did that without setting out any method for dealing with the multi-discharger problem. There may be dozens or even hundreds of permitted and unpermitted discharges into the same water body. In such situations, the pre-1972 enforcement scheme made it necessary for federal authorities to unscramble the polluted eggs after the fact. By 1972, it was recognized that this was impractical. Yet the EPA maintains that Congress retained the backward-looking approach without making any attempt to address the vexing multiple discharger problem. The EPA's only response to this argument is to note that in this case the Oceanside facility is the only entity that discharges into the relevant area of the Pacific Ocean. But the multiple discharger problem goes to the meaning of Section 1311B, 1C, and that provision cannot mean one thing in a single discharger case and another when there are multiple dischargers. Before concluding, we briefly address three additional arguments advanced by the government. The EPA maintains that the imposition of end result limitations is the best course of action when the information necessary to develop additional effluent limitations is unavailable, and it complains that it should not bear the burden of determining what a permittee should do to protect water quality because a permittee is likely to have better access to necessary information and a superior understanding of the operation of its facility and the changes that could be made to provide further protection for water quality. We are not moved by this argument. For one thing, it appears that the EPA and state permitting authorities have used end result requirements routinely, not just when a permit holder has failed to provide necessary information. And in any event, the EPA possesses the expertise, which it regularly touts in litigation, and the resources necessary to determine what a permittee should do. It is also armed with ample tools to deal with situations in which a permittee is slow to provide needed information or is otherwise uncooperative. The EPA can set a schedule for the provision of information and can refuse to issue a permit until the permittee complies. If necessary, it can make use of its emergency powers. The EPA contends that Congress authorized the use of end result requirements when it codified the agency's CSO policy in 1994. And in support of that argument, it cites language in the policy that pertains to Phase I permits. But the permit in question here is a Phase II permit, and the EPA does not claim that its interpretation is supported by any CSO policy provision relating to such permits. In any event, the Phase I language to which the EPA points does not authorize the imposition of end result requirements. The policy states that a Phase I permit should require a permittee to comply with applicable water quality standards, expressed in the form of a narrative limitation. Our decision does not rule out narrative limitations. Limitations, as we understand the term, are permitted under Section 1311b, 1c, and limitations may be expressed in both numerical and non-numerical, i.e., narrative, form. Attempting to read more into the Phase I language, the EPA cites guidance it issued in 1995, but Congress did not codify that guidance, and we are not obligated to accept administrative guidance that conflicts with the statutory language it purports to implement. We also note that other guidance issued by the EPA is arguably inconsistent. Finally, the EPA contends that the rejection of its interpretation of Section 1311b, 1c, would have disruptive consequences for businesses that rely on general permits. General permits cover an entire category of point sources in a given area. Such permits are important for certain businesses, such as home builders, other construction companies, and certain agricultural enterprises, but no such company has submitted a brief supporting the EPA's interpretation. On the contrary, a brief filed on behalf of such companies urges us to reject the EPA's position. What is important, these companies tell us, are narrative limitations other than end result requirements, and they specifically cite provisions demanding compliance with best management practices and operational requirements and prohibitions. Our decision allows such requirements. In sum, we hold that Section 1311b, 1c, does not authorize the EPA to include end result provisions in NPA's permits. Determining what steps a permittee must take to ensure that water quality standards are met is the EPA's responsibility, and Congress has given it the tools needed to make that determination. If the EPA does what the CWA demands, water quality will not suffer. The judgment of the Ninth Circuit is reversed. It is so ordered. Justice Barrett, with whom Justice Sotomayor, Justice Kagan, and Justice Jackson join, dissenting in part. The Environmental Protection Agency issued San Francisco a permit allowing it to discharge pollutants from its combined sewer system into the Pacific Ocean. The permit, of course, does not give the city free rein, and among its conditions are prohibitions on discharges that contribute to a violation of applicable water quality standards. San Francisco challenges these conditions on the ground that EPA lacks statutory authority to impose them. The city is wrong. The relevant provision of the Clean Water Act directs EPA to impose any more stringent limitation that is necessary to meet, or required to implement any applicable water quality standard. Conditions that forbid the city to violate water quality standards are plainly limitations on the city's license to discharge. Notwithstanding the straightforward statutory language, the court sides with San Francisco. I join Part 2 of its opinion, which rightly rejects the city's primary argument. In Part 3, however, the court embraces an equally weak theory, that the permit's restrictions are not limitations, as that word is ordinarily used. The court's analysis is contrary to the text, so I respectfully dissent in part. Under the Clean Water Act, the discharge of any pollutant by any person is unlawful except as expressly authorized. As relevant here, authorization comes in the form of National Pollutant Discharge Elimination System, NPS, permits, which EPA, or, in some circumstances, a state, may issue to allow discharges. Before issuing a permit, however, the agency must ensure that such discharge will meet all applicable requirements under several different statutory provisions. Section 1311b is one such provision. It works in two steps for permits like San Francisco's. First, under Section 1311b, 1a, EPA must set effluent limitations that shall require the application of the best practicable control technology currently available. Effluent limitation refers to a restriction on quantities, rates, and concentrations of chemical, physical, biological, and other constituents which are discharged from point sources into waters subject to EPA's jurisdiction. Second, under Section 1311b, 1c, EPA must impose any more stringent limitation, including those necessary to meet water quality standards, or required to implement any applicable water quality standard. Water quality standards, which are devised by the states and subject to federal approval, consist of the designated uses of the navigable waters involved and the water quality criteria for such waters based upon such uses. Effluent limitations, standing alone, are not always sufficient to protect the desired water quality, as set forth in the water quality standards. So point sources, despite individual compliance with effluent limitations, may be further regulated to prevent water quality from falling below acceptable levels. Importantly, the Act does not itself require dischargers to heed water quality standards. The standards are enforceable only insofar as they are incorporated into permit conditions under Section 1311b, 1c. Section 1311b therefore sets forth a coherent regime. In the first instance, EPA regulates water pollution through technology-based effluent limitations that restrict the quantities, rates, and concentrations of harmful materials that permittees may discharge. But when the technology-based effluent limitations are insufficient to ensure that the water quality standards are met, EPA has supplemental authority to impose further limitations. As the court explains, San Francisco operates a combined sewer system, which transports sewage and stormwater runoff via the same conduits. Such systems occasionally overflow in wet weather, and when they do, they discharge both stormwater and untreated sewage into waters potentially regulated by the Clean Water Act. As relevant here, combined sewer overflow events from one component of San Francisco's sewer system result in the discharge of pollutants into the Pacific Ocean via the Southwest Ocean Outfall, which is located within EPA's jurisdiction, 3.3 nautical miles off the coast of San Francisco. These discharges are presumptively unlawful under Section 1311A and hence require a permit. The city's NPDES permit contains both the technology-based effluent limitations required by Section 1311B, 1A, and additional limitations to protect the water quality standards under Section 1311B, 1C. This latter category includes two receiving water limitations requirements defining the permissible discharge by reference to its effect on the quality of the waters that receive it, rather than by reference to the nature of the discharge itself. These are what the court calls end result requirements. The first states that San Francisco shall not cause or contribute to a violation of any applicable water quality standard. The second provides that neither the treatment nor the discharge of pollutants shall create pollution, contamination, or nuisance as defined by the California Water Code. The city's permit thus tracks the structure of Section 1311B. It restrains discharges initially through technology-based effluent limitations, as required by Section 1311B, 1A. But because the effluent limitations may be insufficient to ensure that California's water quality standards are met, the permit contains supplemental limitations, as required by Section 1311B, 1C. The concern that the technology-based effluent limitations may fall short is on display in this case. Discharges from components of San Francisco's sewer system have allegedly led to serious breaches of the water quality standards, such as discoloration, scum, and floating material, including toilet paper, in Mission Creek. The receiving water limitations imposed under Section 1311B, 1C, are included to ensure that such breaches do not occur. San Francisco dedicates almost all its briefing to the proposition that the receiving water limitations are unlawful because Section 1311B, 1C, allows only effluent limitations. In other words, San Francisco reads the phrase any more stringent limitation to mean any more stringent effluent limitation. As the court explains, this argument is flatly inconsistent with the text of Section 1311B. In my view, the failure of that argument should have ended this case. The court continues, however, with a theory largely of its own making. Whatever any more stringent limitation may mean, the court says, it does not authorize EPA to direct permittees to comply with the water quality standards. This conclusion is puzzling. The entire function of Section 1311B, 1C, is to ensure that permitted discharges do not violate state water quality standards. And as discussed above, the provision gives EPA broad authority to achieve that aim through conditions imposed in NPA's permits. Why would that broad authority not allow EPA to tell permittees that they must not cause or contribute to a violation of the very standards that Section 1311B, 1C, serves to safeguard? The answer, according to the court, is that a restriction does not count as a limitation if the permittee must identify the steps necessary to comply with it. San Francisco's permit only authorizes discharges that do not degrade water quality below the applicable standard. It is up to the city, however, to formulate a plan to achieve that result. The city's plan, the court asserts, is a limitation on its discharges, but the permit condition is not. As best I can tell, the court thinks that only the direct source of restriction or restraint apparently, the most specific restriction, counts as a limitation. The court offers nothing to substantiate this proposition, and it is wrong as a matter of ordinary English. It is commonplace for limitations to state that a particular end result must be achieved and that it is up to the recipient to figure out what it should do. For example, a company could impose spending limitations by requiring each branch to spend no more than its allotted budget, while still leaving branch managers flexibility to determine how to allocate those funds. A doctor could impose a limitation on a patient's diet by telling the patient that she must lose 20 pounds over the next 6 months, even if the doctor does not prescribe a specific diet and exercise regimen. And an airline could impose a limitation in the same manner. In this context, limitation is simply a synonym for a restrictive condition. And conditions can be stated at many levels of generality, including in terms of end results. A college may condition a scholarship on the student's maintenance of a minimum GPA. A homeowner may condition payment for a new roof on the contractor's satisfaction of industry standards. An employer may condition job perks on the employee's performance. In each example, the condition is a limitation on a benefit or payment. There are strings attached. The court also misconstrues the reference to limitations that are necessary to meet or required to implement the water quality standards. As for the former phrase, necessary to meet does not imply anything about the specificity or concreteness of the limitations adopted by EPA. Rather, the limitations on San Francisco's permit are necessary to meet the water quality standards because without them, the standards would not bind the city. The limitations thus ensure that San Francisco will comply with, fulfill, satisfy, or come into conformity with the water quality standards. Nor does the phrase required to implement help the court. Implement generally means to give practical effect to and ensure of actual fulfillment by concrete measures. That is true but incomplete. The full definition reads, to carry out, accomplish, fulfill, especially, to give practical effect to and ensure of actual fulfillment by concrete measures. So while the word is often used in the sense of taking concrete measures, such measures are not necessary to satisfy the definition of implement. Regardless, the receiving water limitations implement the water quality standards in both the broad and narrow senses of the word. They are required to carry out, accomplish, or fulfill the standards. When effluent limitations fall short, discharges from the city's combined sewer system will otherwise degrade water quality below the applicable standard. And the limitations are concrete measures because they are the means by which EPA implements any applicable water quality standard. They give the standards practical effect by making them enforceable. There is no getting around it. The receiving water limitations are limitations. If they are vague or unreasonable, they are vulnerable to challenge on one or both of those grounds. But even a vague or unreasonable limitation is still a limitation. With the text of the relevant provision against it, the court tries to marshal support for its approach from the Clean Water Act's history, as well as from what the court describes as the broader statutory scheme. Neither helps. As for the statutory history, advancing a specific theory of the congressional intent behind the Clean Water Act, the court contends that EPA's interpretation would revive the backward-looking policy regime that the act was designed to replace. Before the act, the United States enforced federal water pollution laws primarily through abatement actions. Though the act abolished this cause of action, the court claims that receiving water limitations function in essentially the same way. Just as the United States did when it brought abatement suits, EPA would have to work backward from an overpolluted body of water to combat water pollution. Thus the court insists, the use of receiving water limitations would undo the act's shift from abatement suits to direct restrictions on polluters. Of course, no theory of what Congress plainly sought to achieve could justify an implausible interpretation of the statute. Here, however, the court does not even deliver on the claim that its account plainly tracks Congress's goal. Because receiving water limitations do not actually replicate the old abatement regime, the court's rendition is not the only, much less the most obvious, explanation for the statutory before and after. There is another explanation, and it is one in which receiving water limitations fit right in. Under the old system, the United States could bring abatement actions only after the pollution had already occurred. A glaring problem with this approach is that an ex post enforcement regime does not adequately deter polluters or prevent pollution. Making matters worse, this regime involved cumbrous enforcement procedures that made it next to impossible to bring abatement actions. Congress chose a different regulatory model when it adopted the Act in 1972. The Act renders all discharges presumptively unlawful. Then, under the current ex ante permitting regime, EPA authorizes only those discharges that comply with the Act. Should a permittee fail to comply with the terms of its permit, EPA has broad authority to sue. The receiving water limitations imposed are entirely consistent with this scheme. Again, the technology-based effluent limitations do the primary work of gating discharges at the front end to minimize pollution. The limitations guard against any residual risk that discharges will violate the water quality standards. Because these limitations supplement rather than replace the technology-based effluent limitations, there is no risk that broadly worded receiving water limitations will recreate the ineffective abatement regime that prevailed prior to 1972. Furthermore, the receiving water limitations operate within the broader context of the Act's permitting regime. These permits impose a prospective requirement on permittees to comply with permit conditions. A permittee who violates a permit condition, by contrast, necessarily exposes itself to enforcement actions by EPA, as well as potential penalties. Receiving water limitations, like any other permit condition, thus operate as direct restrictions on polluters. The court also claims that the receiving water limitations are inconsistent with two features of the broader statutory scheme. First, it contends that the receiving water limitations are at odds with the permit shield provision because violations of the permit condition, and the attendant liability, are hard to predict. Second, It argues that the Act is silent about the problem of multiple discharges into the same body of water, and if the Act allowed EPA to condition a permit on maintaining water quality standards, the court says, it surely would have spelled out how to deal with such an obvious complication. Both of these arguments boil down to the court's concern that receiving water limitations might be unfair to permittees. In some circumstances, they might be. But any unfairness should be addressed through arbitrary and capricious challenges, not a statutory rewrite. Start with the permit shield provision. Under the statute, compliance with the terms of a permit shall be deemed compliance with various substantive provisions of the Act, thereby shielding permit holders from liability. The court insists that receiving water limitations like those in the city's permit would eviscerate that benefit by failing to provide fair notice. The permit shield provision, however, serves the specific role of immunizing permittees that comply with a permit. For instance, it insulates permit holders from changes in various regulations during the period of a permit and relieves them of having to litigate in an enforcement action the question whether their permits are sufficiently strict. The receiving water limitations do not eliminate that benefit. It remains true that San Francisco cannot be sued under the theory that the city's permit is insufficient to ensure compliance with the Act. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.